Okay, so we are at the end of week 2 under the new Trump administration, and it's really hard to summarize all of the changes that have been going on since then. Too many executive orders to mention, um, but I'll just kind of briefly talk about what a lot of my clients are going through. So first, everyone is really worried about their future, their immigration status, what is going to happen to their immigration application. And for immigration attorneys, now is a really hard time to provide any answers because it's quite a chaotic time. Um, so I think the most common question that I'm getting from clients right now is what's going to happen to me? What's going to happen to my family? What will happen to my application that is pending with immigration? And I wish I had a crystal ball, but no one can predict the future. Um, what I am seeing is that immigration is focusing a lot on enforcement. You know, Trump promised that he was going to do mass deportation, and now I'm sure a lot of people have been seeing this in the headlines, hearing about ICE raids in a lot of cities, just basically all throughout the country. And the question is, who is a target, right? Um, so one thing is that the administration has expanded something called expedited removal. So expedited removal is a rapid track to deportation. And in the past, it was only focused on within 100 miles of both the Canadian and Mexico borders. So if, you know, CBP, Customs and Border Protection, or ICE, Immigration and Customs Enforcement, came across any individuals that they had reason to believe was undocumented, then they could technically take that person into custody. And if they determine that the person did not have immigration status, they could just put them through expedited removal, which basically means no right to appear before an immigration judge to contest the deportation, no due process rights to have your case heard in court. So under the Trump administration, this limitation on just applying to 100 miles within the borders has been lifted, right? Now it applies to across the country, including the interior of the United States, well far past the borders. So the focus is anyone who entered the US without inspection, basically meaning without a visa, they enter through the border. And if they have not been living in the United States for more than 2 years, then they are going to be targeted for expedited removal. So that's a significant change from decades of practice of the immigration agency. So in reality, what we're seeing is that because Trump also gave marching orders to ICE, he wants a quota of minimum number of arrests per day. I think the number is 1,800 arrests per day, and there's 25 ICE offices. So that pretty much means he wants at least 75 individuals arrested per ICE office. You know, with this type of pressure, what I'm hearing anecdotally from other immigration lawyers across the country, as well as hearing also from the immigrant community, is that ICE is conducting sweeps and picking up anyone who they think is not here with lawful status. This includes people with no criminal record. And, you know, the whole PR angle to Trump's mass deportation was that he wanted to round up all the quote unquote criminals, right? Equating immigrants with being criminals. But, you know, I've heard a lot of accounts by now of immigrants who have been picked up through this whole massive sweep. And even if they don't have any criminal record, they're still being detained and in some cases, processed for deportation. Um, so what this has done is it's generated a lot of fear among the immigrant community. And what I'm also hearing is that even if a client has already a pending deportation case in immigration court, meaning immigration already knows about the person, they already processed that person and placed them into deportation proceedings. And let's say the clients have already filed some application for relief from removal with USCIS or with the immigration court. Even some of those individuals are being picked up in these sweeps and processed for expedited removal. So as you can imagine, a lot of folks are really scared about, will I be the next one who's being picked up, even though I have a pending, let's say, asylum application or TPS, I have TPS, right? So there's a lot of confusion about, what could happen to um, pending applications, individuals who are already facing court proceedings, right? Let's say they already have an individual hearing date set in immigration court. They already have an application that's filed, and an immigration judge is supposed to review that application and make a decision. Well, if ICE is going through communities and arresting people and detaining them and possibly deporting them, what does that mean about due process? The right to appear before an immigration judge, which is provided by law. So that's what's going on. That's what I'm hearing from a lot of my clients. And I think for me as an immigration attorney, it's hard for me to give concrete advice because simply the future is unknowable, right? I wish I had a crystal ball and I could say, well, you're going to be fine because XYZ reason. But I can't say that because, ICE, I think, is not really um, screening every single person they encounter and going uh, through checks and balances and seeing, well, has this person lived in the US for more than 2 years, right? There's a whole issue about these encounters. When someone is detained by law enforcement, there's a question of whether or not there was a reasonable suspicion that that person was in violation of law. I don't really know how closely these procedures are being followed. So you can imagine that immigration attorneys are looking into these, was there any trampling of rights here? Was someone racially profiled, right? How did the ICE officer make the determination that this person in particular was undocumented, right? So under criminal law, you could file a motion to suppress evidence that was, for example, fruit of the poisonous tree, if an officer did not engage in that analysis. Do I have a reasonable, articulable suspicion to arrest this person? So that's kind of like my high level summary of what's been going on. We're only in week 2, so who knows? We have quite a long, uh, this is not going to be over by any time soon. And, I hate to be the bearer of bad news, but it just looks like most of the concentration now is on enforcement, right? Not about adjudicating immigration applications. And I think a lot of the decisions that are coming from the administration don't always make sense. So something else that happened yesterday was that so for the immigration courts, right, there's a practice manual that instructs immigration lawyers and also ICE attorneys, like how do you submit evidence? What is the proper way of serving the opposing party? Any evidence or applications that you want to be filed in court. And out of nowhere, the existing practice manual was just kind of completely taken off of the immigration court's website. So a lot of immigration lawyers were confused and wondering, well, what rules apply now, right, regarding proper submission of documents to the court and also to the opposing party. And I think recently, within just yesterday or the day before, a new practice manual just suddenly appeared on the immigration court's website. And as immigration lawyers are going through the manual and reading it, one thing that popped out was this whole question of serving papers. So before, um, it was allowed for private practitioners to electronically serve documentation on Homeland Security, right? And also on immigration court. Now, all of a sudden, under the new practice manual, private lawyers cannot serve ICE electronically. Instead, it has to be hand delivered to the court that has jurisdiction over the case, or it has to be filed by hard copy mail. So a lot of immigration lawyers are scratching their heads and wondering, why was this change implemented? How does this, what's the reasoning behind it? Because it just kind of doesn't make sense. The whole electronic filing became really a necessity, especially during the pandemic. And it seemed to be in the interest of efficiency, right? Being able to electronically serve all the parties. Um, a lot of attorneys welcome that change because, reduction of making photocopies, not having to send something off and, pay additional costs of postage. And then also the time it took to get the document received by the other party or the court. So it doesn't, like, it doesn't really quite, it's not really clear why this change was made. And the more interesting thing is that rule about requiring serving papers either in person or by, old-fashioned mail applies to the private bar, but not to government counsel. So in other words, ICE counsel can still electronically serve documentation on the private attorneys. So there's the question of like, well, how is this fair, right? That one side gets to electronically serve if they wanted to, but then the other serve can't. Like there's the optics of it is a little, you know, um, a little unfair in my opinion. So just a lot going on and not everything seems to really make sense. And I myself am questioning, well, who came up with that decision? And what does that serve? Like what good does that serve? Because I don't see it being, um, how does that make the whole immigration court more efficient, right? It's a head scratcher for me.